So, good afternoon, ladies and gentlemen. We are back with the SAP IP Business Talks, and I'm very happy to have a good colleague from New York, from Long Island here, George Likourezos. Thank you very much for being with us.
Thank you, Alex, for inviting me to your broadcast.
You're welcome. George is obviously an IP expert, but basically he is pretty much working with startups and has a huge amount of experience on that. We would like to talk today, this afternoon, at least in Europe, Central Time, we have afternoon. We would like to talk about these interplay between IP, especially patents, and startups. So we are live. That means we are absolutely happy when you give us for the next 45 minutes your thoughts, your comments on LinkedIn, in the chat. We will see that here, and I will pick that up and also ask that to George when there's something very interesting what you would like to ask to us, especially to him. So George, thank you very much for taking the time, for giving us the chance to talk with you. I mean, that's all my guests. I ask the same first question. So IP is a strange field. It's no little boy and no little girl wakes up in the morning and says, "Daddy, I would like to become a patent attorney," or "Mom, I would like to go in the IP field." So
Right.
that sometimes this strange thing happens, but later on. Okay. So the first question is, explain us a little bit about your career, what you studied, what brought you into that field, and what motivates you to stay here to work in this field. We would really like to know a little bit more about your path so far.
Sure. Thank you, Alex. So I started my career in patent law in 1995 is when I graduated from law school. And I graduated engineering school, electrical engineering, computer science from the NYU Tandon School of Engineering in 1992. And I went straight to law school, which is not so typical, I think, for most patent attorneys. They usually work as an engineer or scientist for several years before they are looking at an alternative career, and patent law usually is one of them. But I felt during engineering school that I wanted not to be the person troubleshooting and designing circuits, and to maybe be a manager or maybe do something different in the engineering field. So I did a master's in operations management. And then I said, let me go to law school and become a patent attorney. I researched it. I saw that as a patent attorney, you work with startups, with large companies, you help them with their technologies, protecting them. So I didn't see myself leaving the engineering field. I felt that I'm doing more, something different, but also more for me that will be more interesting in my career. So I pursued patent law, and I went straight to law school after that. And I've been a patent attorney since 1995, working with startups, multinationals, universities, research institutions, individual inventors. And currently I'm a partner at Carter, DeLuca and Farrell. We're an intellectual property law firm based in the US, but we work with companies all over the world.
Wow, that's quite fascinating. And when did it start that you
I think I lost the connection. Okay, I think I see you now, Alex.
Okay, wonderful. What I asked you was, when was the time that you started to be interested in working with startups?
Sure. So I initially, when I started as an attorney, I worked for a law firm. And when you start as an associate, young associate, you are given legacy clients. Usually you work with clients that are at the firm for many years. So I did that for a while. And then I wanted to also go out beyond the office and talk to entrepreneurs, being a little bit entrepreneurial myself, having done a degree in operations management and knowing how businesses work. I wanted to go and meet the companies. So I would go to different events, and I would then get to know startups. I would get to know scale-ups, small businesses. They all had questions about IP. They seemed to want to know more. So I started becoming more involved in different organizations that cater to startups. I became a mentor to, and I'm still am a mentor to several accelerators and incubators like the Sustainable Aero Lab, Starburst Accelerator. So I do a lot of mentoring, working with startups. But I guess it was about 5 years after I started my career that I began working closely with startups and representing them and helping them build their patent portfolios, their trademark portfolios, advising them about best practices. And then also in my networking, got to know investors as well, other service providers that can cater to startups. And I started being more than just their patent attorney and helping them grow by making introductions where I think it will help them with fundraising, help them with their business plan, with their pitch deck, and so forth.
And you did that to, so to speak, just in the United States, just at East Coast, or are you active also in Asia or Europe? What is your focus from a geographical standpoint?
Sure. So up to, I guess, 3 years ago, pre-pandemic, I was basically local New York City incubators, startups in the tri-state area here in New York, Connecticut, maybe up in Boston. But during the pandemic, I've done webinars and I've became a mentor to several accelerators that are not based in the US. And I got to know companies in Australia, Asia, Europe as well. So doing webinars, being a mentor, doing Zoom meetings, you get to work and mentor startups from all over. But initially, up to about 3 years ago, it was primarily companies that you will meet face to face in the local geographic area of my office.
Okay, wonderful. And is there a difference? I mean, is it from a functional standpoint that you work with an US-based startup? Is that different from working with an Australian startup, or is it basically the same challenges, the same issues, but just a different area?
I think it's the same challenges and issues, just a different area. They all want to know how to protect their intellectual property, what they should be doing when they first hire an engineer, when they're working on their technology, where should they be filing, how they should be filing, how soon, how early. I tell them about provisional applications. They also want to know how to enter the US, trademarks as well. So the same issues come up, I find. Sometimes they are also interested in knowing if they open up a US subsidiary, how does that work? You know, I'm not a corporate attorney, but we help them as much as we can, or introduce them to a corporate attorney that will help them build a US subsidiary. So the same questions tend to come up, and they all are interested in coming into the US, either bring their products, their business, or at least protecting their intellectual property in the United States and other countries as well. So we help them manage those decisions, try to align their business strategy with their IP strategy. And so the same issues tend to come up, whether companies here or somewhere else.
Yeah, that I mean, I assume that, but I'm not really experienced in working with startups, and so it's fascinating, because finally it's also from my practice what I've learned is that companies are quite similar, and yes, of course there are certain differences because of the legal framework or the branch, but basically it's the same mechanics. I mean, management is nothing. There is no US management or an European or Asian management. I mean, when we talk about scientific management and business administration, so it's a ubiquitous theme which has to be done everywhere. I mean, what you mentioned is that so you said you help startups to protect their IP. I mean, that is what I would expect, right? But so basically, it becomes harder and harder. So we have a venture winter. So it becomes harder and harder to get finance. The rounds are, so the valuations go down at the moment for macroeconomic reasons. So it becomes more difficult to get finance rounds. And typically startups, of course, I mean, business administration or economy is always the game of limited resources, right? no question how big you are. So big companies have big budgets, but they have big problems, and small companies have small budgets, but the smaller problems.
True.
So it means it's always a limited budget, but especially startups has really financial needs, and they discuss, so should we invest in IP? So what is your perspective about that? So what can you recommend, and why do you think it absolutely makes sense to give that scarce resources into an IP portfolio from the perspective of a startup? Or and can we say in general startup, or does it depends on the business model or on the technology or so?
Correct, right. So it depends on the company, on the technology. So when it comes to patents and maybe trade secrets, but then you also have your brand, your logo, your taglines, so your trademark protection, your brand protection throughout the world. So startups, based on what type of technology they're working in or different space they're working in, they are always in need of some IP. It could also be copyrights if they're doing publishing or if they're doing graphic design. But we primarily work on the patents and trademarks, and we're helping them, advise them on trade secret protection. So yeah, I always say when I give a webinar, one of my first slides to startups is your IP is your most valuable asset, because I don't think a lot of startups comprehend that. They think it's the engineering team. They think it may be their technology that they are going to develop, but without IP to back the company up, you really are not a technology startup. You really need to have your IP. Initially, when you start your startup, a technology startup, for instance, everything is a trade secret. So startups usually don't comprehend that part of that phase of their company, when they are developing their technology and hiring engineers to work on that technology, all that is trade secret information and should be maintained as a trade secret. And it should be, according to the US cases, you have to have reasonable measures that you have to put in place. So if somebody misappropriates your trade secrets, or you have an engineer that leaves your company, there's an understanding that the information that was known to that person was a trade secret, and it won't be taken to somebody competitor, for instance. So trade secret protection is important. Startups should realize that. Maybe they'll be talking to an investor. Maybe initially they may be talking to engineers they may want to bring over to their company, and they may be describing what they're working on to entice the engineer to come join them, or to the investor. But you need to have certain safeguards in place, because if you disclose, first of all, you may be blocked from filing your patent application in countries other than the US, which gives you the 1-year grace period. But also, you've given away trade secrets, and it could devalue the company. And also, investors want to see.
Excuse me, maybe that's the most so in the early phase, that's the most important danger, right? That you are so happy, so proud about what you know, and you want to tell that everybody what you know, because at the end you think that is why somebody is investing in you, and you give that all away, and also to cooperation partners and suppliers and everything. So all what you have is your knowledge, and
Exactly.
and so you cannot show a big building or a big machine or whatever. It's the know-how, and you have the tendency to explain it to everybody. But I think that is a big challenge, and to work with the startup to explain what makes sense, what is good and what is not good, or even extremely dangerous, that you lose a lot of value when you're doing that.
Correct, right, exactly. And investors appreciate if you give them an NDA to sign. Sometimes startups may be hesitant to do that, but an investor wants to see that your corporate culture has and is aware of IP and protects it. That's more appealing to an investor than you just telling them what you're working on without requesting that they sign an NDA. And then also with the corporate culture, when it comes to IP, a startup from the beginning should have an IP policy in place, and everybody they hire should understand that the technology is a trade secret. The invention disclosures should be filled out, if not on a daily basis, at least on a weekly basis. Your engineers should describe what they are working on, what their solution is, what the problem that they're solving. Even if it's not the best solution, they should at least document it, because that information may be worthwhile of putting it into a patent application, even if it's not your best solution, while you are still working on getting to your optimum solution. It's always good to tell your engineers everything should be documented. And I find that startups make that mistake. They hire engineers, they tell them, okay, we want to solve this problem, and they let them do what they want to do, and they don't document their discoveries, what they tried, what failed, what did
Yeah.
work, and that
Yeah.
needs to be documented from the beginning.
I mean, what you're saying, basically, that's a typical lawyer perspective and a typical US perspective, a document. But to be honest, I mean, that's one of the most important things, right? That you get. I mean, we had the investors, right? And these investors want to see that the startup understands that IP is the most valuable asset. Basically, I mean, the investor invests in people, of course, because there are only people and they should be convincing. But then after I have the people, it's a question, what do they know, and on what they are working. And that is so important, especially what you're saying, this documentation, this attitude of being able to document that, even when it is negative know-how, so what doesn't work, that can have a huge value. Basically, George, sorry for disturbing you, but we have some questions which I would like to pick up. Just one is very interesting, and we talked about the regions. Okay, so the different continents and jurisdictions. So when just reduce it for a patent and for getting patent granted. Is there a certain time advantage when you do that? I don't know, in Europe or in the United States or in Australia or wherever. Are there certain timing issues there? So that you want, for example, as fast as possible a granted patent. So what would you do? Is that a question of jurisdictions?
Sure. So I think the best when you are based in Europe or you're based in Australia or the US, you are in this global economy, you are a worldwide company. So filing in the United States, I always think is the best idea. And the best vehicle to do that, I believe, is the provisional patent application. I don't think any country in the world has anything like that. And I think it's a gift to startups, the provisional application. The ability to file something early when you have an idea and you have some data, some research that's been done, and then to follow it up maybe with a second or third or fourth provisional application as you develop your technology. And you kind of keep putting stakes in the ground. I keep saying that. You put stakes in the ground, so at least you get that filing date early because it's first to file the global patent system. So you want to protect your IP, your technologies as soon as possible. And I think the provisional application is the best way to do that. It doesn't require a full amount of a write-up. I mean, the more you put in it, the better, because it only protects the subject matter that you disclose. So I think filing a provisional in the United States is a good first start. And also a provisional doesn't get published. So if in a year you will need to convert it to maintain that early filing date, but you don't have to convert it. You can decide that this could be a trade secret. You can decide that you are not ready to file, even though maybe filing might be the best to convert it because you want to preserve your early date. But it doesn't get published. You can decide during that 1 year period whether this is information that can be kept best as a trade secret, whether we can convert it to a regular application and file it in the US and maybe file it internationally as well. So a good first start for any startup is to meet with their patent attorney, get all the information that they know, their technical information, put it in a document, and have the patent attorney review it, add to it, ask questions, and try to make it as robust as possible, and then file it.
And you wrote a paper. I just would like to show that to the audience in a quite sophisticated quantum computer journal. I would like that you put the link on that paper later on in our LinkedIn chat, so make it available to everybody. Is what you wrote there about provisionals here, especially in this quantum computing report? So is that specific for quantum computing, or can it be applied in every technology?
Sure, good question. So I wrote the article tailored to quantum computing because the magazine was Quantum Computing Report, but the benefits of filing provisional applications apply to any technology, whether it's life sciences, robotics, medical devices, AI. So it's the same benefits. You want to file early. You want to align the business strategy with your filings, and a provisional is a good way to do that because you can get an early filing date. You can then decide later on what provisional applications you will like to convert, which ones can you combine perhaps into one regular application. And it gives you the benefit also of getting the most important thing is to get something on files early and make sure that nobody else files before you do.
Yeah, and basically it's the same logic again. Documentation is king. So I mean, also provisional can be seen as a kind of documentation, and I think that's a very good. So when people, IP is very complex, and startups have so many issues. So we should have something in a nutshell which you can convey and say, okay, think in that direction, and the way of all what you know is really it should be a trade secret. All what you know is your asset. It's valuable, and you should document it when it is in correlation to your business model, to your technology, and so on. And this provisional thinking is very powerful, I guess. By the way, a wonderful comment here from Dr. Arikan. Thank you very much. That she said in France, what I didn't know, even when I'm a professor in France, but I can't know anything, everything. Maybe I know something, but I definitely don't know everything. In France, we have provisional applications, and she says that this is something very helpful for French startups. So we have to invite our colleagues from France to discuss with them that situation a little bit. So I mean, when it comes to startups, so obviously they have, as we said, by nature, very limited resources, especially they don't have a IP department. I mean, that doesn't make any sense, of course. That's clear. So, and maybe they have very limited IP knowledge, IP understanding. And that's also quite normal. I mean, that's even when we talk about top management decision makers in bigger companies, they don't know anything about IP. So that's, so to speak, the normal situation. Nobody has an education despite of some IP experts. So obviously there can be done, they can do mistakes, misunderstandings. So what would you think? Could you give us a summary? What are the biggest mistakes which you should avoid? Is there a kind of top lists from your long-standing experience, 25 years? I mean, there's a lot what you have seen.
Sure. So the number one rule is you do not disclose anything before you at least file a provisional application. Even if you do file a provisional application, and you should then have an NDA in place. So one mistake I find is startups usually think an NDA is good enough, and they may not have filed their provisional. They're working on their technology. They have an NDA with maybe a strategic partner, a company. So they think that NDA is good as it is, which is fine. It is good because it prevents the other person from disclosing your information, your confidential information. But then when you meet with your strategic partner and you're having discussions on the technical aspects of your invention, and maybe they bring in their engineers, now it almost becomes a joint development effort. And any IP that comes from those meetings will likely be co-owned by your company and then the strategic partner. So they may not even need to do a deal with you, because now they are co-owners of the IP. And if you file a patent application, they should be listed as inventors and also potentially owners of the patent. So you should have different agreements in place, not just the NDA. You may have a joint development agreement in place as well when you have these deep technical discussions, to make sure that any IP that comes out of these meetings is owned by your company, your startup.
Yeah.
But even having said that, it's always good to file provisionals before you have those technical discussions. Get together with your team and figure out what those discussions will be like a month before the meeting happens, and brainstorm the ideas that may come out of that meeting ahead of time. So then you can file provisional applications and technical solutions, things that may be discussed. So if the other side volunteers information or contributes to what your design is going to be, there's probably a good likelihood you already discussed it with your team, and maybe it's included in your provisional and you have an earlier filing date than when those meetings took place. So I always say to startups, even if you have an NDA, consider filing your provisionals and brainstorm with your team and file more provisionals before having any meetings where the technology is going to be discussed. So that's one thing. And then another thing is, don't lose sight of the fact that the technology always evolves. You should always be looking at what the engineers are. Maybe they pivoted, maybe they came up with something different. Go back and make sure your IP covers those alternative methods. If it does, you may need to file a continuation application to cover something that perhaps you wrote claims to one subject matter, but then write claims to something else that you are now doing. Maybe file a continuation in part application on the new subject matter. Maybe file a provisional and start a whole new patent family on the new. So technology evolves in your business, and the IP should evolve with it, and it should be in sync. It shouldn't be two separate things going on.
Yeah,
I mean, should be talking with the business and the R&D, the researchers. Everybody should be one team.
I mean, that is I think the cornerstone what you're saying is that this IP thing is nothing completely separated, something far away from your business. It is really the cornerstone, because at the end, investors really ask, how do you work? How do you treat your IP? And then when you can explain that, provisionals, continuations, and so on. So when you are more or less safe in explaining how you develop your startup and how you align your IP activity with the development of the startup. I mean, that's enormous. And I saw a lot of pitches. We worked with some accelerators, and the typical way. So what I saw is that startups are completely over confidential in terms of, we covered everything, we patent everything, so it's done. Where I say, I would be quite careful with saying that, especially when you derive out of we patent everything means we are allowed to do what we would like to do. I mean, this separation of freedom to operate and patenting, you should be aware about that, especially when you are a startup, or to be completely incompetent. So saying, IP is nothing what we have to take care about, or something like that. So I mean, this two-folded thing is not really helpful, right?
You're right. That's very important. I mean, IP is very important, and like you said, freedom to operate is another thing I see with startups. They seem not to understand whether something's patentable and you have a freedom to operate. It's two different analyses. They sometimes confuse the two. So we tell them a patent is a negative monopoly. It allows you to exclude others from doing what you're doing, or importing or manufacturing or selling, but it doesn't mean that you can do it yourself, and then you have to explain about the freedom to operate. But I find more startups nowadays understand the concept of freedom to operate more than perhaps 5-10 years ago. So that's a good thing to see, startups being more educated. And I think that's because there's a lot of patent attorneys like myself that do webinars, that are mentors to a lot of the accelerators. We get in front of startups, we do workshops, and I think the knowledge is getting out there more so than maybe 10 years ago.
Yeah. I have one thing which I would like to ask, because I think that's a very important question from Dimitris, and he said he comes from the value perspective, and that's also, I mean, costs are one thing, right, and prices, but he says, okay, two things. How can we value a patent? I mean, there are thick books. At least I wrote a 1,000 pager on that. But basically, it's the market approach, and you ask what will be the future benefit to your business model based on this exclusivity. But what would you say when it comes to investments and the value discussion of the startup? I mean, from my experience, it makes a huge difference whether you can show your freedom to operate analysis, you can show your provisionals, maybe some patents, some trademarks, you made your homework, you had a certain exclusivity for aspects of your business model. I mean, that is a big issue, and that has an enormous contribution to the overall company value. And we saw that again and again. We have plenty of case studies out there. And I mean, what is your perspective on that?
Sure. I mean, all those are good factors that you should be looking at. So I think being able to understand the scope and breadth of your claims, how broad is your patent? Is it first in a certain technical field? It doesn't have to be, but how early has it been? Is your patent fall into the technology evolution of that industry? Looking at the file history, what did you say to the patent examiner? Did you say something that maybe limited the scope of your claims? And if there's more patents in the portfolio, in the patent family, than just one patent, usually one patent by itself will not have much value than if it's a portfolio. And we tell this to startups, it's good to maybe have one patent that defines your technology. Maybe it's your core technology, but then you want to build around it and have more patents that perhaps are secondary patents that may not go to the core, but they go to several features that adds to the strength of your portfolio, and maybe even having some other patents as well in a different area. So the more patents and IP that you generate, the better it is. But there's valuation firms that will look at different factors. Usually law firms will not value other than looking at the risks of the patent. So will I be infringing somebody, the freedom to operate issue, if I buy this portfolio?
But basically, I mean, George, what you're saying, in my ears, what you're saying is stay close to your patent attorney, stay close with somebody who has, from the first day, a value perspective on your IP activities. I mean, the whole thing is about creating value. And as you said, make sure that your communication with the patent office don't gives you later on problems. And I have at least two comments here. Also, one from Hans. He's saying that that there is a certain disadvantage with provisionals, because that maybe is then later on not a good basis for patent application. I would say this is the reason why you should choose quite carefully your patent attorney, and should work with them closely. And that is not a good idea when some startups simply try to do that on their own, and that is obviously not a good idea. And also here another nice comment from Raphael is that also these provisionals and the question how we are using that. Again, I would say also Catalina said something about that companies, startups are in hurry, so they have time pressure. And again, it depends on having a good wingman with you, or wing women, and help you with this kind of homework, and that you don't need to hire somebody. Here it is important having somebody in place who knows exactly the startup situation, and that is very specific. And I would say it's not enough just being a patent attorney working with that very specific situation of startups. Any comments from you to this issues which comes from the chat?
Sure, definitely you should have a patent attorney review your provisional applications before you file it. And I agree there should be more than one filed, especially if you're developing a core technology that's innovative. You want to file your initial provisional, then follow it up with additional provisionals. And then when you convert it at the 1 year mark from your first provisional, you can claim priority to all of them, or maybe not maybe leave one out. So that's why it's another strategy to file more than one provisional. Maybe in one provisional, you have your technical data or your technical information, which is easy to see by the eye, your hardware. Another provisional may be data that you derived doing the testing. Another provisional could be maybe some information that you may not want to disclose to the public at some point. So that could be your trade secrets, and that you may want to put as a separate provisional, because if you blend it with your hardware provisional and then you convert it, at some point that provisional will be accessible to the public. I said earlier, provisionals do not get published, but they, if you do convert, they are accessible to the public. So you don't want to put any information in your provisional that could be a trade secret, like marketing data, who your consumers are going to be. I've seen startups make mistakes where they'll put their pitch deck as part of their provisional, and the pitch deck may have their projections, they may have their strategic partners, prospective customers. So a lot of that has to be sanitized. Your provisional application should only include your technical information, and filing more than one provisional is a good idea to separate out different ideas. So later on, you can just determine if all those ideas should be in one application, maybe file a separate application, maybe don't file on one provisional because some of that information may be a trade secret. Like that's why I said earlier, provisional application is a good gift for startups. And it's not expensive. Usually we work with startups where their technical team may put together a technical document with figures, and then we review it from an attorney's perspective based on some of these points I just said, and then maybe also adding some additional information to the provisional in consultation with the client, or have them go back and further elaborate on some issues that we think may need more information, more subject matter to be included.
Thank you. Okay, thank you. So I would like to come to I mean, you work a lot. You studied electronics, and you do a lot also in you wrote the paper on quantum computing. So my question is, when it comes to this really high tech fields, like at the moment artificial intelligence. So last year, all the investors wanted to invest in Web3 and NFTs and on these things, blockchain. And now we have the blockchain winter, and nobody touches blockchain or NFTs. That's bad. And now we go everybody after ChatGPT, every investor wants to invest in AI. So
Right.
I mean, it's a fad. Nobody wants to be missed out, and so we see this investments and lots of startups, really tons of startups working around AI technologies, and for good reasons, because what everybody learned now is how powerful that might be and that can become. And so it's a good reason to think about IP and AI, and especially from a startup perspective. So, and when there is a very specific topic on AI, and this is the machine learning aspect of it. And when we talk about machine learning, we talk about training data.
Right.
And there are, of course, certain really critical IP issues assigned with. And typically a startup won't be able simply to buy data or don't have the data, basically, on which they can train the machine. So the machine learning comes from data which is typically not in the direct access of the startup. So what is your recommendation, experience around licensing training data, so getting access to training data? So what can we do here?
Sure, that's a good question, because AI is a growing field. There's many startups in that, and there's many applications that are filed in AI. Even though people may say software is difficult to patent, AI tends to win the day, usually with the examiner. So when you are creating an AI model, obviously you create it as a startup, but then you need to have some training data, like you said, and you may not have it. So you have to go out to a third party to get training data to train your model. So again, you have to make sure that there's an agreement in place with that third party that you will use the training data, but any model, I guess the trained A model, after you run the training data through your A model, will be your property, your intellectual property, because the third party can argue that without such an agreement, they contributed to the creation of your trained AI model by providing you with their trained data. And then also the trained AI model will then shoot out an output, data output, and there may be a question who owns the rights to that data. It may not be patentable because it's data, but it could be trade secret. It could be a copyright protection around it. But the fact that your third party that you license the data from can argue that the trained data model now is potentially their property as well should make any startup pause and make sure an attorney looks at your licensing agreement. Your don't use a typical conventional software development agreement. This is not software development. This is licensing training data. So I see startups sometimes try to take something online and try to make it fit, but you need an attorney to look at those agreements, making sure that you own the IP that to the trained AI model. Perhaps there's a sharing agreement in place where you share some of the revenue with the third party, so you don't have to pay them up front for the data. If you're a startup, maybe that could be more appealing to the third party to license you the data. So there's a lot of issues that go around that. And also the trained AI data that you are licensing.
So, excuse me, what you say is we have at least two aspects, okay? So one aspect is that this ownership issue, that you say the training data is anyhow adapting, changing the model, feeding the model, that the model becomes the model, because before it was just a frame for let's say a model, but now it is a trained model, and the trained model is something different from the untrained model, and the untrained model has only a very limited value. The value comes from the training. Okay, and that leads to this ownership issue, right?
Right. So you have to make sure that you are the startup is the owner of that trained AI model. Even though you license the training data, the model that's trained will be your property, your intellectual property.
And that should be a part of that licensing contract. Is that correct?
Exactly right. That should be in the agreement that the trained AI model will be your intellectual property. That you're not the third party.
Okay, and the other aspect is then that you have any kind of remuneration you have to pay for getting access, and there you say, now there are at least two options. You pay in advance, you pay for the access when you have the access, or you say I find an agreement that I pay when I have a certain success, when the model is earning anyhow money, and then I pay.
Sure.
That I was able to use your data. Is that correct?
Correct. Right. That could all be in the contractual negotiations where you'll maybe don't pay up front, but pay later based on the success or the revenue that the startup will receive by teaming up maybe with another company to use the AI model in their business, or you use the AI model as a startup to generate revenue.
Okay, and anything else? What should be integrated here, which is mission critical?
No, just always be aware that there's IP everywhere. Sometimes you think, I'm taking AI training data from somebody, make sure that somebody's IP, and they can make a claim that they're developing your IP. So always know that IP should be front and center. Always be out on the lookout for trade secrets, things that you can protect, so as a competitive advantage to your business. But also always think of IP and develop that culture. Every startup should have a culture of IP where you have meetings, brainstorming sessions on a regular basis. It kind of brings the team together, and they understand what IP is. Maybe have a patent attorney in those meetings to make sure everything is harvested, and then kind of work with the management team to figure out what should be protected, maybe as a provisional, maybe something should be filed directly as a non-provisional. And also, somebody said earlier about investors may want IP to happen faster. There's strategies to do that. You can do in the US, a track one application where you pay a little bit extra when you file, and you may get a patent within a year. Then you can use that to your benefit when you go internationally and go under the patent prosecution highway to show that you may have a US patent. So there's ways to also appeal to investors by growing your portfolios faster.
Well, George, thank you very much. We could talk for hours. No problem about that. But the time is over for today. So thank you very much. And I would like to summarize this fascinating chat with be careful. IP is everywhere. That's a very good, that famous last words. Thank you very much, George.
Thank you.
Take care. Have a good time in New York, Long Island. And I'm happy to meet you again. Thank you very much.
Thank you. Thank you.
Bye-bye to the audience. And we are in the after show party. We go on LinkedIn. George is there. I will be there. And I'm happy to discuss further. Bye-bye.
Bye.